Retrenchment. What is retrenchment? So first we see definition of retrenchment. It is given in Industrial Disputes Act 1947, section 200. Okay, so what is retrenchment? Retrenchment is termination of service of a workman by the employer for any reason whatsoever, mainly surplus labor, otherwise than as a punishment inflicted by way of disciplinary action. So retrenchment is termination of service of a workman by the employer for any reason whatsoever, like mainly it's because of surplus labor, the labor is more than required, but it should not be due to punishment inflicted by way of disciplinary action. Okay, it should not be, the termination should not be because of as a punishment, okay, by way of disciplinary action. What is not included in retrenchment? The termination due to voluntary retirement is not included. Retirement on reaching superannuation age, retirement age, okay, it is not included in retrenchment. Termination due to continued ill health, if the person is ill for continuing period, then the termination due to continued ill health will not be included in retrenchment. Or there is non-renewal of contract, okay, if there is a contract of employment between employer and the workman and it has expired, then it has not been renewed, then the termination due to non-renewal is also not retrenchment. So these are exceptions to retrenchment. What are the essentials of retrenchment? That the industry must be continuing, not closure. The termination due to closure of industry is not retrenchment. The industry should be continuing. The service should be terminated. Okay, it should not be temporary layoff or paid leave. Okay, it should be termination of service. The main ground is surplus labor or staff. The labor or staff is more than required. Service must have been capable of being continued. Okay, the labor must have been capable of doing the service at the time of retrenchment for any proper reason, not punishment. And exceptions, it can be for any proper reason, not punishment, as we have seen in the definition. And these exceptions, the reason should be proper, rational, economy, or labor saving machines have been installed. Okay, so there is no need of extra labor, or any other industrial or trade reasons. So these were the essentials of retrenchment. Now see, conditions precedent means the conditions which should be satisfied first before retrenchment. So these are given in section 25F, that there should be 1 month prior notice. Okay, the notice should be in writing, not oral. There the reason should be mentioned in the notice. The retrenchment can be done after the period expires. Okay, after the notice period expires, period must expire, or paid wages for period of notice. If termination is before the notice period expires, then the employer has to pay the wages of the notice period. Paid retrenchment compensation, 15 days average pay. Before retrenchment, the compensation should be paid to the workman, called retrenchment compensation, which is equal to 15 days average pay. The workman should be in continuous service for not less than 1 year. If conditions are not complied, retrenchment void ab initio. If these conditions are not satisfied, then the retrenchment will be treated as useless from beginning. Okay, so these were the conditions precedent, conditions which must be satisfied before retrenchment. What is the procedure of retrenchment? The procedure is given in section 25G. 25G incorporates rule last come first go, or first come last go. 20 Section 25G gives the rule. It's that this rule is written in section 25. Okay, that the person who came last in the industry, he must be the first to go out of the industry, he must be the first to be terminated. Or the first person who came first in the industry, he must be the last person to go out of industry, okay, to be terminated out of industry. Section 25G is applicable only if all conditions satisfied. If all these conditions given below are satisfied, then section 25G will be applicable. These conditions are that the person must be a workman under section 2S, okay, that he should be a citizen of India, The industrial establishment should be an industry under section 2J. The person should belong to a particular category. Okay, the categories are like unskilled labor, this category. Okay, and skilled labor have as another category, manual labor other category. Okay, there should not be any agreement between the labor and the workman and employer in which there is any condition which is contrary to last come first go. Okay, then this rule, retrenchment, cannot be applied. Now see, what is this rule, last come first go? Rule last come first go. It is statutorily incorporated under section 25G. Okay, it is written legally in that section, where other things are being equal. Okay, where all the other things are being equal, like all unskilled labor are equal. Okay, they are all unskilled, or all skilled labors, they are all skilled, being equal, then this rule is applied. It is intended to safeguard against discrimination. It is intended to secure equitable treatment. It is applied category wise. Okay, like there are two categories, unskilled labor, skilled labor. First this person joins the industry, then this, then this, then this, and then this, then sixth. Okay, if the retrenchment is going on of unskilled labor, so if retrenchment is going on of unskilled labor, then first fifth will go out of industry, then third will go out of industry. It's not like that after fifth the fourth will go out of industry, because it is another category, skilled labor is another category. So this rule is applied category wise. If this rule is violated, retrenchment declared invalid. Okay, if last come first go rule is violated, then the retrenchment will be declared invalid. There are some conditions or situations where there can be departure or deviation from rule, where the rule cannot be applied. Okay, these conditions or situations are when there are extraordinary situations, then the employer cannot, the employer will not apply this rule. When it is in interest of the business to not apply this rule, or there are special grounds like inefficiency, unreliability, irregularity, like there are unskilled laborers 1 2 3 4 5. Okay, if the fourth person he is inefficient, unreliable, or irregular, then he will be retrenched first instead of fifth. Okay, or someone is retained because of special qualifications in interest of business, like if the fifth person has some special qualifications which is in interest of business, then he will be retained and fourth one will be terminated. The reasons for not applying the last come first go rules, they must be sufficient reasons, sound reasons, valid reasons, justifiable reasons, and bona fide. Okay, if they are not valid or sound reason, then it will be inferred. Okay, it will be said that there was improper motive of the employer, there was ulterior consideration, malafide. Okay, and it is treated as an unfair labor practice, and it is victimization of the workman. It was said in JK Iron Steel versus Workman condition case. Okay, the burden to substantiate. Okay, there, the burden to substantiate a special ground for departure. Okay, the departure from the rule last come first go, there must be special grounds for it. It's an speaking order. Okay, absence of malafide not sufficient. The if the employer says that there is no malafide, there is no ulterior motive, it is not sufficient. He must gives the proper reasons. Okay, the burden to prove deviation is on management or the employer. The burden to prove is not on workman. The employer must record the reasons for the deviation from rule, why he didn't apply the last come first go rule. Okay, what is the effect? If the retrenchment is violating last come first go rule, the retrenchment will be declared invalid. Okay, unless it is supported by valid and justifiable reasons. Okay, if the employer violated these rules, okay, then the tribunal may reinstate that workman. Okay, and pay remuneration or compensation to that workman. This was retrenchment. Let's have a quick revision. First, we saw the definition. It was said that its retrenchment is termination of service of a workman by the employer for any reason whatsoever, other than as a punishment by way of disciplinary action. What was not included in retrenchment? Voluntary retirement, retirement or retirement age or superannuation age. Termination is due to continued ill health or non-renewal of contract. Okay. What were the essentials of retrenchment? That the industry must be continuing, not closure. There must be termination of service. The grounds must be mainly surplus labor or staff more than required. Service must have been capable of being continued. The retrenchment must be for any proper reason, not punishment and exceptions. The reason should be proper, rational economy, labor saving machines have been installed, or any other industrial or trade reasons. What are the conditions precedent? The conditions which must be fulfilled before the retrenchment is done, they are given in section 25F. That there must be 1 month prior notice given. Okay, the notice must be in writing, and the reasons must be stated in the notice. The period must expire. Before the expiration of period, he should not do the retrenchment. If he does the retrenchment before the notice period expired, then he has to pay the wages for the period of notice. Before retrenchment, he has to pay the retrenchment compensation, which is equal to 15 days average pay. The workman should be in continuous service for not less than 1 year. If these conditions are not complied, okay, they are not complied, then the retrenchment will be void ab initio. It will be treated as useless from beginning. What is the procedure of retrenchment? It is given in section 25G. Section 25G incorporates rule last come first go or first come last go. This section 25G is applicable if all conditions are satisfied. What are these conditions? The person should be a workman under section 2S. He should be a citizen of India. The industrial establishment should be an industry under section 2J. The workman should belong to a particular category. There should be no agreement between the employer and the workman which is contrary to last come first go. Now let's see what is rule last come first go. It is statutorily incorporated under section 25G. Where other things are being equal, its intention is to safeguard against discrimination. Its intention is to secure equitable treatment. Retrenchment or last come first go rule is applied category wise. If this rule last come first go is violated, then retrenchment will be declared invalid. When there can be deviation or departure from the rule, or when the rule cannot be applied, when there are extraordinary situations, or it is in interest of the business to not apply this rule, or where there are special grounds like inefficiency, unreliability, irregularity, then that person will be terminated before any other person. Any person may be retained against last come first go when he has special qualifications which are in interest of the business. The reasons for deviation of or not applying this rule must be sufficient reasons, sound reasons, valid reasons, justifiable reasons, bona fide. If they are not valid or justifiable or bona fide, then it will be inferred that the motive was improper, there were ulterior consideration, it was malified, it comes under unfair labor practice, it is victimization of the workman. It was said in JK Iron and Steel versus Workman. The burden to substantiate that there must be a special ground for the departure. It's an speaking order. Merely saying that we did the deviation from the rule, it was absence of malified, it is not sufficient. Okay, there must be proper reasons stated. The burden to prove the deviation from the rule is on the management or employer, not on the workman. The employer must record the reasons why he deviated from the rule, why he did not apply the last come first go rule. What is the effect? If retrenchment is done violating last come first go rule, it will be declared invalid unless supported by valid and justifiable reasons. Okay, if the retrenchment is done violating LCFG rule, last come first go rule, the tribunal may reinstate that workman back to the industry and pay remuneration or compensation to that workman. So this was retrenchment. If you want the PDF for the revision, the link can be found in description box or comment box. Next we will see layoff in next video.